Right. Good evening, students. I'm Rohit, and today we have to start the appointment procedure of the judges of Supreme Court and High Court. See, in the last class, I have discussed that what are the constitutional provisions for the appointment of the judges of Supreme Court and High Court. And today we have to discuss the controversy over consultation. And I think you all remember that in the last class, I've discussed that why there is controversy related to consultation. And today we will see how this controversy was settled. So let us start the controversy over consultation. Controversy over consultation. Okay. And now, as I've discussed, that we will study the 4 judges case. So we will start with the first judges case. First judges case of 1982. Now remember, in the first judges case, the question was asked from the Supreme Court that what is the meaning of the word consultation? Okay. We are only discussing those points which are relevant for the topic, that is controversy over consultation. I know many things were discussed in this case, but we are concerned only about the appointment procedure. So in the first judge's case, the question was asked from the Supreme Court that what is the meaning of the word consultation? Now in this case, the Supreme Court passed a judgment which can be seen in favor of the government. And in this case, the Supreme Court said that the word consultation means the exchange of views. Now, what is the implication when the Supreme Court said that the consultation means exchange of views? It basically means the advice given by the Chief Justice of India to the President is not binding on the President. It is merely a consultation. President is not bound to follow the advice of CGI. It means the government has the discretion in appointing the judges of Supreme Court and High Court, because the advice given by the CGI is not at all binding on the President of India. So when I say the consultation means exchange of views, it basically means that the advice given by CGI shall not be binding on the President of India. President of India. So when it comes to controversy over consultation, you have to just remember this particular point. I mean these 2 points in the first judge's case. Okay. Now starting the second judge's case. Now remember, the second judge's case can be considered as a landmark judgment. Why landmark judgment? Remember, in this case, the judiciary passed a judgment in its own favor. Why I am saying this? Because when we will discuss that what all judiciary said, you will automatically understand that yes, this decision is in the favor of judiciary. And remember, this decision was given at the time when we had coalition era. In 1993, there was coalition government, and whenever there is coalition government, the position of the prime minister weakens. It means the executive is weak, and consequently, the judiciary is strong. This is a pattern which we have seen in our country, that whenever executives are strong, we have seen that judiciary is somehow weaker. But when the executives are weak, judiciary is strong. So in coalition era, the government is weak government. Why I'm saying a weak government? Because the government is dependent upon the coalition. If the coalition withdraws the support, then the government has to resign. So that is why this was a coalition era, and during coalition era, the judiciary became powerful and passed a judgment in its own favor. So in the second judge's case, first of all, Supreme Court changed the meaning of the word consultation. We have seen that in 1982 case, the judiciary said that the consultation means exchange of views. But in this case, judiciary changed the meaning of the word consultation. And now judiciary is saying, I mean the Supreme Court is saying that the word consultation does not mean exchange of views. It means concurrence. So when I say concurrence, it basically means the advice given by the CGI shall be binding on the President of India. This is the exact meaning of the word consultation now. So when I say consultation means concurrence, it means the advice given by the CGI shall be binding on the President of India. The advice given by the CGI shall be binding on the President of India. Yeah, I was confused whether I had written not or not. Yes, shall not be binding, and now shall be binding on the President of India. Okay. So I hope you understood that what Supreme Court said in the second judge's case. The consultation mean concurrence. It means you have to follow the advice given by the CGI. Now, here you will understand that what is the informal amendment in the Constitution. See, one way to amend the Constitution is under Article 368. Whenever amendments in the Constitution are done under Article 368, then we can call them as formal amendment. Okay, but these can be considered as informal amendment. Why? See, still in the Constitution, you will find the word consultation, but the Supreme Court has changed the meaning of the word consultation, and now the consultation stands as the concurrence. So the word remains the same, but its meaning has been changed by the Supreme Court. So it means there has been an informal amendment because the word has not been changed, but its meaning has been changed. This we call as informal amendments, and these informal amendments are done by the judiciary. For example, in Article 21, it is mentioned, no person shall be deprived of his life and personal liberty except according to the procedure established by law. So there is emphasis on the procedure established by law. But the Supreme Court in Menka Gandhi case said that in India, instead of procedure established by law, we have due process of law. That is, the law passed should be fair, just and reasonable. It means the legislature cannot make any arbitrary legislation. It can be questioned. So it means in Article 21, you will find procedure established by law, but the meaning is now the due process of law. So again, there has been no formal amendment, but still the meaning of the word, meaning of the phrase that procedure established by law has been changed to due process of law. So these are called as informal amendments. Okay, now one more thing. In the last class, I said that there was, there was a time when the convention was broken. You remember that those three judges were not appointed as the CGI, but Ajit Nath Ray was appointed as the CGI because of his judgment in the Kesavanan Bharati case. Similarly, M.U. Beg was appointed as the CGI despite being the second most senior judge of the Supreme Court. Okay, and H.R. Khanna was not made the CGI. So what we have seen that the convention was broken by the government, that too twice. Okay, so in this case, the Supreme Court said, what I can say, the Supreme Court re-established the convention, and the convention was that the senior most judge of Supreme Court should be appointed as the CGI, and in this case, Supreme Court re-established the same convention. So what we can write is that the senior most judge of the Supreme Court, the senior most judge of the Supreme Court, the senior most judge of the Supreme Court should alone be appointed as the CGI. I hope you all can establish the link that why Supreme Court is saying that only the senior most judge of the Supreme Court should alone be appointed as the CGI, because this was the convention which was in force from 1950 to 1973. Because of Kesavanan Bharati case and in ADM Jabalpur case, the government broke the convention, and now it's time for the Supreme Court to re-establish the convention. So the senior most judge of the Supreme Court should alone be appointed as the CGI. Now, what else Supreme Court said about the appointment procedure in this case? Now we all know the advice given by the CGI shall be binding on the president. Now, in the constitution, there is a confusion. I think in the last class we have discussed that the president, while appointing the judges of Supreme Court, he has to consult the CGI and such judges of Supreme Court and High Court as he thinks fit. So the constitution has said it depends upon the president that from how many judges he wants to take consultation. So there is no precise number that what should be the exact number of judges giving advice to the president while appointing. So what happened in this case, Supreme Court clarified that how many judges are going to give advice to the president. Okay, so Supreme Court in this case said that the president, while appointing the judges of Supreme Court, whenever the president will appoint the judges of Supreme Court, see, the president will appoint the judges of Supreme Court, and the president, while appointing the judges of Supreme Court, has to take consultation, and we all know consultation is binding on the president. Now, who will give the consultation? So, according to Supreme Court, the consultation will be given by the Chief Justice of India and two senior most judge of Supreme Court. So, together, these three judges will give the advice to the president that you appoint this High Court judge as the judge of Supreme Court. So, these three judges are going to give the advice, and this advice will be binding on the president. Now remember, these three judges, I mean the group of these three judges is called as collegium. So now this is again an important point, that the collegium system was started in the second judge's case. It was in the second judge's case when the Supreme Court introduced the collegium system for giving advice to the President of India in matters of appointment to the judges of Supreme Court and High Court. However, the collegium was restricted to the appointment of Supreme Court judge. Okay. So I hope you understood what I have written. So what I have written, that the president, while appointing the judge of Supreme Court, has to take consultation, and he will take consultation from CGI and two senior most judges of Supreme Court, and their advice will be binding on the president. Now, in the same case, Supreme Court said about the judges of High Court. So what Supreme Court said, that the president, while appointing the judges of High Court, because we all know the president has the authority to appoint the judges of Supreme Court as well as High Court. So the president, while appointing the judges of High Court, has to take consultation. Now, from whom he will take the consultation? The answer is, here you will not find the collegium. We are in 1993, and in 1993, the collegium was introduced only in the case of appointment of Supreme Court judge. There was no collegium in the case of High Court judge, because here the president will take consultation from Chief Justice of India, and here Chief Justice of India will not consult the other senior most judges of Supreme Court. Okay, so here CGI has to consult two senior most judges. So collectively they will give consultation to the president, but here only CGI will give consultation to the president in matters of appointment of the judges of High Court. Okay, so what we can say, the collegium system was introduced in the second judge's case, and it was for the judges of Supreme Court, but not for High Court, because only in High Court there was only CGI, dominance of CGI, no role of any other judge of the Supreme Court. So this was the second judge's case. So all the relevant points, all the relevant points have been discussed in the second judge's case. Okay, now what about the third judge's case? The government was confused after the second judge's case that what should be the exact procedure for appointing the judges of Supreme Court and High Court. So the president referred the case to the Supreme Court, and the president wanted that the Supreme Court must clarify that exactly how many judges, what should be the procedure for the appointment of the judges of Supreme Court and High Court. So the government wanted to clarify the exact procedure for the appointment. I mean, who will give the consultation, how many judges will give the consultation. So in 1998, the government wanted to know the exact criteria, I mean the exact procedure. So the next case is the third judge's case. Third judge's case, 1998. So in this case, the government wanted the clarification for appointing the judges of Supreme Court and High Court. So in this case, Supreme Court said that while appointing the judges of Supreme Court, the president will take consultation, and he will take consultation from CJI and four senior most judges of Supreme Court. So a collegium of 5 judges will give the advice to the President of India when it comes to the appointment of judges of Supreme Court. So earlier, how many judges were there in the collegium? Only 3 judges. But now what Supreme Court said? Instead of 3, there will be total 5. CGI plus 4 senior most judges of Supreme Court. And the Supreme Court this time introduced collegium even in the appointment of High Court judges. Now, what Supreme Court said for the High Court judges? Supreme Court said that while appointing the judges of High Court, the president has to take consultation, and this time he will take consultation from CGI and two senior most judges of Supreme Court. So it means now we can see the collegium even for the appointment of judges of Supreme Court. And remember, in the collegium, there will always be the judges of Supreme Court. You should not expect that while appointing the judges of High Court, the CGI will consult the matter with the judges of High Court. No. In collegium, they will be the judges of Supreme Court. So it means here you will find 5-judge collegium. These are 5 judges of Supreme Court. Here you will find a collegium of 3 judges. These are 3 judges of Supreme Court. There is no role of High Court in the collegium. Okay, in collegium you will find the control of the judges of Supreme Court. So the president, while appointing the judges of High Court, has to take consultation from the CGI and 2 senior most judges of Supreme Court. So these 3 judges of the Supreme Court will choose the name, they will decide the name and will give the name to the president, and the president will be appointing the name as the judge of Supreme Court, as a judge of High Court. So I hope you understood the difference between the collegium for appointing the Supreme Court and for appointing the judges of High Court. Now, one more thing, what students usually think that the collegium is responsible for appointing the judges. No. The task of appointing the judges of Supreme Court and High Court is of the president. It is the task of the president to appoint the judges of Supreme Court and High Court. So what is the role of collegium? The role of collegium is to give consultation, which is binding on the president. So collegium does not appoint the judges of Supreme Court or High Court. Collegium is there to give consultation, to give the advice to the president. Okay, so remember the difference. The president appoints the judges, whereas the collegium just gives the consultation, which is binding on the president. Okay. So this was the 3rd judge's case. Okay. Now what happened? With time, there were allegations, and allegations were that there is nepotism in the collegium, there is no transparency in the collegium, there is no openness in the working of the collegium. So with time, there were allegations against the working of the collegium, that they are they are appointing only those persons as the judge of Supreme Court who are their relatives or their favorite in the High Court. So these were the charges or allegation against the collegium system. So obviously, when there were charges against the collegium system, so there had to be a solution. What will be the solution? In 2014, when Modi government assumed the power, so when Modi assumed the power, then the Modi government decided that there should be a better procedure than the present collegium system. And collegium system is filled with flaws, according to according to various news or discussion, you will find that there are many flaws in the collegium system. So what Modi government wanted to do was to replace collegium system with a better system, okay, which is more transparent, and there is no scope for nepotism, favoritism. Okay, so what the Modi government did? Modi government in 2014 took a bold step of replacing the collegium system with a better system, and that better system was called as the National Judicial Appointment Commission, NJAC. So now we will discuss what is the NJAC and why it failed, because even at present you will find that there is the role of collegium in appointing the judges of Supreme Court and High Court. So what happened with NJAC? Why the NJAC failed? Okay, so let us discuss the NJAC. So the government wanted to replace collegium, and for replacing the collegium, it thought that this system will be better than the collegium system. And the system is National Judicial Appointment Commission. National Judicial Appointment Commission. Okay, we can call it as NJAC. Okay, so now first of all, let us discuss what was the composition of NJAC. and then we will discuss that why it was struck down in the upcoming case. So the National Judicial, see, first of all, you should understand that what is the role of NJC. The NJC has been introduced, or sorry, the NJC was introduced to replace the collegium system. Till now, what we have seen, the president was taking consultation from the collegium. And for Supreme Court, 5 judges collegium, and then for High Court, 3 judges collegium. So the president was taking consultation from collegium. Now, why there is NJC? NJC will replace the collegium, and now from now onwards, the NJC will give consultation to the president. Okay, so first of all, let us understand that what was the composition of the NJC. So NJC consisted of total 6 members. Okay, now out of those 6 members, 3 were from the judiciary. So out of these 3, one is Chief Justice of India, and the remaining 2 are the senior most judge of Supreme Court. So from the judiciary, there were total 3 members in the collegium, and the remaining 3. So out of these 3, one was the law minister, union law minister. Okay. Now the remaining 2 were the eminent person. Eminent person. Okay. The remaining 2 were the eminent person. So remember, now how we will decide that who will be the eminent person. So in order to select the eminent person, a committee will be constituted. So under this system, there will be a committee for appointing or for choosing 2 eminent person. Now this committee will consist of the CJI, Prime Minister, and leader of opposition. Leader of opposition. Okay. So a committee consisting of these 3 will choose 2 eminent person, and these 2 eminent person will be there for a period of, I guess, 3 years. Okay. Now one more thing. Out of these 2 members, one eminent person should be from either SC or ST or OBC or women or minorities. So out of these 2, one should be from this SC, ST, OBC, women or minority. Okay. And they are not eligible for reappointment. I mean, these 2 eminent persons are not eligible for reappointment. So this was the composition of NJC. 3 from the Supreme Court, one is the law minister, and these 2 eminent persons will be selected by a committee consisting of CGI, Prime Minister, and leader of opposition. So what happened actually? Judiciary sensed that there are some inherent flaws in the functioning of NJC and its composition. Now, why there is a flaw in the composition of the NJC? What you can see that there is a definite role of the executive in the appointment of the judiciary. See, law minister is a part of executive, so definitely he will always take the side of the government in appointment matters. Now, what we will see that in the committee there is the role of prime minister. So definitely there is the influence of executive in the NJC. So what judiciary sensed that this is somehow going to affect the independence of judiciary. Why? It now all depends upon the functioning. See, suppose there are 5 names, and out of those 5 names, 2 are the judges of High Court who gave the judgment against the ruling government. So suppose 2 judges gave the judgment against the ruling government. It was not at all appreciated by the ruling government. Let us, for example, the central government imposed president's rule in Punjab. Okay, so the president imposed president's rule in Punjab. Now the Punjab Haryana High Court said that this president's rule is unconstitutional. Okay, so what happened? Now this is an embarrassment for the central government that the president imposed president's rule and the High Court said that it is unconstitutional. So now what will happen when the NJC will consider the name of that judge who gave the judgment against the center related to president's rule? Then the government will oppose the name of that person, because in NJC, out of these 6 members, even if the 2 members says that this name should not go to the president, then this name will not be sent to the president. So out of these 6, even if 2 says that no, this name should not be appointed as the judge of Supreme Court, then he will not be appointed as the judge of Supreme Court. So it means that if any judge has passed a judgment which is not at all liked by the central government, then the central government is going to take revenge from that judge. And whenever there will be time for his promotion to the Supreme Court, the NJAC, the central government will try to use veto by directing the law minister, and suppose out of the 2 eminent person, one is on the side of the government, which is not a tough task. Okay, but you can see at present that it is far easy for the government to influence anyone. So what will happen? Law minister is always on the side of the government, and out of these 2 eminent person, even if one is on the side of the government, then these two will collectively veto the name of the person who should be appointed as the Supreme Court judge. So this thing will send a message to all the judges that if you will pass a judgment against the central government, then the central government is not going to consider your name for the appointment to the judge of Supreme Court. Every time the government will try to veto on the name of that High Court judge, because that High Court judge passed a judgment against us. So now we are not going to appoint him as the judge of Supreme Court. So this is somehow going to affect the independence of judiciary, because now all the judges will think that if we really want to become the judge of Supreme Court, then we must think about our judgment. If our judgment is not appreciated or liked by the government, then the prospect of appointing as the judge of Supreme Court are far less, or of High Court are far less. So this was the main problem in the functioning of NJAC. Even if 2 members out of 6 said no, then that name will not be sent to the president. And out of those 2, one is always from the government. And even if 2 eminent person, even if the one is on the side of the government, then the independence of judiciary is compromised. So that is why, considering all these probability, the Supreme Court in the 4th judge's case said, now let us see what is, just now we have discussed the functioning of the NJC and composition of NJC, and now let us see what government tried to do to introduce NJC, and then we will see what Supreme Court said. So what government tried to do? Government introduced the 99th Constitutional Amendment Act 2014 and NJAC Act 2014. Now, these 2 steps were taken by the government to replace the collegium and to introduce the NJAC system. And we all know that there is no provision of collegium in the constitution. The collegium was invented by the Supreme Court in the 2nd judge's case. In constitution, you will not find the procedure of taking advice from the collegium. No, there is no such provision in the constitution. So there is no mention of collegium in the constitution. But the government wants that there should be provision for the NJAC in the constitution, and that is why it introduced 99th Amendment Act. And by the 99th Amendment Act, Article 124A was inserted in the constitution. Now this particular article dealt with the NJAC. And what will be the composition of NJAC, its functioning, all was mentioned in the NJAC Act of 2014. Okay, so what government did? Government tried to replace NJAC and to give constitutional status. Sorry, the government tried to replace collegium and to introduce NJAC. And not only it is trying to introduce NJAC, it is also trying to give the constitutional status to the NJAC. Okay, so it will have the constitutional status. And once it had the constitutional status, it will not be easier for the judiciary to ignore the NJAC. Okay, so what happened? These 2 steps or these 2 acts of the government were challenged in the Supreme Court in the 4th judge's case of 2015. So these 2 steps taken by the government were challenged in the 4th judge's case of 2015. So it was the 4th judge's case in which the constitutional validity of 99th Amendment Act and NJAC Act was challenged. Okay, so the constitutional validity of these 2 acts were challenged in the 4th judge's case. So what Supreme Court said in this case? Supreme Court said that the 99th Amendment Act and the NJAC Act, they both are trying to compromise the independence of judiciary. And judiciary was right that these 2 steps were actually trying to compromise the independence of judiciary, and judiciary in this case held that independence of judiciary is a part of basic structure, and there can be no amendment which can violate or affect the basic structure. So judiciary, what judiciary said in this case, that independence of judiciary is a part of basic structure. Independence of judiciary is a part of basic structure, is a part of basic structure. Okay. And there can be no amendment which can affect the basic structure. So from now onwards, independence of judiciary is part of basic structure, and these two acts are trying to affect the basic, or I mean they are trying to violate the independence of judiciary, that is basic structure. So Supreme Court said that because of these two, the basic structure is affected, and that is why these two are unconstitutional on the ground of violating the basic structure of the constitution. Okay, so I hope you all understood that why the Supreme Court declared 99th Amendment Act and the NJC Act as unconstitutional. They were declared unconstitutional on the ground that these two acts were affecting the independence of judiciary, which is a part of basic structure, and no amendment of the parliament can affect the basic structure. There can be no violation of the basic structure doctrine. Okay, and I don't know whether you know about the basic structure or not, whether you have heard about the basic structure, but the basic structure doctrine is the innovation of Supreme Court. This innovation was done in the case 1 and the Bharti case. What the parliament was trying to do, the parliament was trying to amend the constitution according to its own will. Okay, so the parliament wanted to amend the entire constitution. So what the Supreme Court did, the Supreme Court introduced the doctrine of basic structure, and the doctrine of basic structure can be seen as the brake. Okay, the engine of the parliament was running, and the brakes were the basic structure. So basic structure stopped the engine of the amendment by the parliament. So we can see the basic structure as the limitation upon the power of the parliament to amend the constitution. Okay. Actually, I don't know whether I've discussed the topic basic structure of the constitution or not, but while discussing the topic basic structure, we will see that by the 42 Amendment Act, the government was trying to give to itself the unlimited power to amend the constitution. So it was in the Minerva Mills case where the Supreme Court held that the power to amend the constitution is limited. I mean, the parliament cannot assume unlimited power to amend the constitution, and the limited power to amend the constitution is a part of basic structure of the constitution. So according to Supreme Court, the parliament cannot amend the entire constitution because parliament is the creature of the constitution. The constitution has created the parliament and not the other way. Okay, so the parliament does not possess the unlimited power to amend the constitution. So I hope you understood that what is the significance of basic structure, and the basic structure can be seen as a step in the right direction, because India would have gone in the path of other countries where we will see that there is no constitution. I mean, even if there is constitution, then no one is following the constitution. We can take the example of Pakistan, where there is a constitution, but you will not find the importance of that constitution because everything is under the control of military. All the major decisions are taken by the military, and this was not envisaged in the constitution of Pakistan. So there are many countries where there is constitution just for namesake, but in reality there is no constitutionalism. Okay, so India would have gone that way, but thanks to the judiciary that they came with the doctrine of basic structure, which can be seen as a right step. Okay, so I hope you all are able to understand that why the fourth judge's case can be considered as a landmark judgment. Okay, because it stopped the government, it applied the brake on the engine. Okay, so with this we are done with the appointment of the judges of Supreme Court and High Court. And now remember, in the fourth judge's case, the 99th and NJC both were declared unconstitutional. So now at present what we will see is the third judge's case in force, because in fourth judge's case both were declared unconstitutional. So at present, what is the procedure? The procedure is same what you have seen in the third judge's case. The 5 judges collegium giving advice to the president in matters of appointment of Supreme Court judge, and the three judges collegium giving advice to the president in matters of appointment of judges of High Court. Okay, so the same third judge's case is in force. Now, after the appointment procedure, now we can start the oath. Now, the basics oath of the Supreme Court and High Court judge. But before starting the oath, let me discuss about the High Court. That what is the provisions for High Court? I mean, see, according to Constitution, there should be a High Court in each and every state. Okay, in every state you should find a High Court. But by the Seventh Amendment Act, a provision was inserted, and according to this provision, a common high court can be established in two or more states. Now, this particular amendment is important. That which amendment said that a common high court can be established for two or more states. Ideally, what Constitution wants that there should be a high court in each and every state. But what Seventh Amendment did? According to Seventh Constitutional Amendment Act 1956, a common high court can be established. A common high court can be established. A common high court can be established for two or more states. Okay. So now it is possible for the government to constitute a single high court for multiple states. So do you think there are any common high court in a country? Yes, there are total 3 common high court. Now, what are those 3 common high court? So the first common high court is Punjab and Haryana High Court. Punjab and Haryana High Court. Now it is a common high court for Punjab and Haryana, as the name suggests. Now the second is Bombay High Court. Bombay High Court is common for how many states? For 2 states, Maharashtra and Goa. Okay. Now the third is Guwahati High Court. Guwahati High Court. Now Guwahati High Court is for 4 states, 4 northeastern states. Okay. So these are the 3 common high court. Now, what about the union territories? I mean, do they have their own high court? At present, only 2 union territories have their own high court. The first is Delhi, having Delhi High Court, and the second is the Jammu Kashmir Ladakh. I mean, total 3. There is Jammu Kashmir High Court for Jammu and Ladakh, and for Delhi there is Delhi High Court. So now we will discuss that what is the position of union territory. I mean, they come under the jurisdiction of which high court. So now let us see. Because after this we will start the oath, salary, term, retirement, all these things. So for union territory, so for Jammu and Kashmir and Ladakh, you will find that there is Jammu and Kashmir High Court. Jammu and Kashmir High Court. For Delhi, there is Delhi High Court. For Delhi, you will find Delhi High Court. Now, for Chandigarh, there is Punjab and Haryana High Court. Punjab and Haryana High Court. Okay. Then for Daman and Diu, now they both are one. Daman, Diu, Dadra, and Nagar Haveli. So for Daman and Diu, and for Dadra and Nagar Haveli, there is Bombay High Court. There is Bombay High Court. Okay. So now Lakshadweep. For Lakshadweep, you will find there is Kerala High Court. Okay. For Puducherry, you will find Madras High Court, and then last is Andaman and Nicobar Islands. For Andaman and Nicobar Islands, you will find that there is Calcutta High Court. Calcutta High Court. But remember, you should not think that if the jurisdiction, I mean, for Andaman and Nicobar Island, there is Calcutta High Court, so every time they have to cross the sea to approach the court. No, there is a circuit bench of the Calcutta High Court in Port Blair. Okay, so you can approach the Port Blair bench of the Calcutta High Court. So this is for the union territories. Okay, so before Jammu and Kashmir, I mean, we all know that before 2019, Jammu and Kashmir and Ladakh both were the state. Okay, Jammu Kashmir collectively. But so then only Delhi was the union territory having its own high court, Delhi High Court, from since 1966. The Delhi had its own high court. But now even the union territory of Jammu and Kashmir and Ladakh, they have their separate high court, that is Jammu and Kashmir High Court. Okay, so these are for the I mean for the union territories, that which union territory comes under the jurisdiction of which high court. Okay, so with this we are done with the appointment procedure. Appointment took time because obviously appointment needs to be discussed in detail, because there have been, I mean, there are issues with the appointment procedure. There is always dispute between the government and the judiciary when it comes to the appointment procedure, because somehow the government wants its control over the appointment of judiciary. The government wants its interference, but judiciary is somehow resisting the interference on the ground that judicial independence is affected, which is the part of basic structure of the constitution. So now we can start with the oath of the judges of Supreme Court and High Court. So oath is simple. See, in Supreme Court there is Chief Justice of India, and then there are judges of Supreme Court. Okay, and in High Court you will find there is Chief Justice of High Court, there is Chief Justice of High Court, and then there are judges of High Court. So remember, when it comes to the oath, see, the oath to the CGI and judges is administered by the president. So the oath to the CGI and the judges is administered by the president, and the oath to the Chief Justice of High Court and judges is administered by the governor of the concerned state. Now here students are confused. See, the judges of High Court along with Chief Justice were appointed by the president. So the president appoints the judges of High Court. But when it comes to the oath is administered by the government, and this is the only role of the governor when it comes to in the judiciary. Okay, because when it comes to the appointment, there is no role of governor. When it comes to the transfer, there is no role of governor. Even in the removal, there is no role of governor. So what you will find that the governor, I mean the main role of governor when it comes to the judiciary is the oath. So the oath to the judges of High Court is administered by the governor of that particular state. Okay, there is no role of president in administering the oath. Okay, so the remaining portion of the Supreme Court and High Court will be discussed in the next class. So in the next class, we will start with the salary allowances, the tenure of Supreme Court High Court judge, the resignation, removal, and remember removal is important. And then we can start with the jurisdiction of Supreme Court and High Court. And the most important jurisdiction of Supreme Court High Court is the power of judicial review. And not only the power of judicial review, it is also the writ jurisdiction of Supreme Court and High Court. So we will discuss the writ jurisdiction and power of judicial review in detail in the next class. Okay, for now, goodbye everyone. Thank you.